Good morning. Thank you very much for joining us today at the Q1 Legal and Compliance Update for Letting Agents with David Smith, and David will introduce himself in a moment. We've got a busy agenda as always, including a very recent addition about the disclosure of material information after an announcement, I believe it was yesterday. And so we'll be digging through that, court cases, upcoming legislation, and lots more. So for those of you who are as legally geeky as David and I, this is going to be a roller coaster.
Speak for yourself. Don't put me into your geek.
We'll see whether that's proved or disproved as the hour progresses. So for those of you who've been with us before, welcome back. For anyone new, we do want to hear from you. So there is a Q&A bar at the top of your screen provided by the Zoom webinar tool. Please put in any comments, questions, insights that you have, and we've got time allotted at the end to deal with them. As always, this is for general information purposes only and is not and must not be construed as legal advice, although I'm sure that if you have a question on a specific legal conundrum that you're facing or would like advice, our guest would be happy to assist through his law firm JMW, and his details will be available to you at the end of the webinar. And with that, David, over to you. Would you be happy to introduce yourself to the audience?
Yeah, I never know what to say in these situations. I'm a partner in a London law firm, and I have long specialised in residential property law with particular focus on landlord and tenant law and regulation of the sector. Raj says I know something about it. Some people may or may not agree. How about that?
That is a perfect introduction. And also worth highlighting that the second edition of David's book about GDPR for property professionals has just been published. And so if you are involved in residential lettings in the UK and interested to know of any changes that have come out and any clarifications from the first edition, it's available at all good bookstores. I'm going to say Amazon, but is that right?
It is now on Amazon, yes.
Excellent.
Reviews would be welcome as well. So I do like it's always nice to have an Amazon review.
So into the first topic, which is very timely because the Part A has just been released. Mandatory disclosure of material information. David, what's your view on the announcement? So it's definitely not regulation or legislation, but the announcement by national trading standards as it relates to lettings. And I guess more broadly, there are a couple of interesting points in there for sales.
Yes, I know someone's already asked the question as if it was legislation. It's not. The legislation has always been that you must give prospective tenants and purchasers and people carrying out transactions material information. And they must be given it prior to making a transactional decision. But obviously, material information has never been defined. It's deliberately not defined, in fact, because what's material, it varies from sector to sector. The regulations cover a huge range of different trading stuff. They're not just about lettings and estate agency. In fact, if you look at the prosecutions, they're almost always about garages. So they cover a vast range of consumer environments. So the idea that the regulation should specifically say what's material for each sector would be bonkers. NTS ELAT is entitled to have a view on what is material information, and no doubt their guidance is welcome. But currently, the only arbiter of what is material information or not is the court. It's notable that no estate and letting agent really has been prosecuted, at least not to a level that's been reported under these regulations. They don't tend to come up much. And no senior court has really focused on the concept of material information. So that, I mean, the first point I would make is that what NTS ELAT has said is guidance at best. It is their view on it. Their view is obviously one which people should respect, but I should also point out that they've had views on stuff before, not all of which were correct. So there's a variable sort of thing. I mean, go on, Raj.
So it's quite interesting. So of the information that's stated, and I'm just going to focus in on the lettings sector here and then perhaps jump back to sales. Council tax, the price, including deposit, it's not extensive or onerous. It's quite interesting that it seems like the portals are on board from what I read in the press release.
Yeah,
Do
and I
you
think
think this is going to be challenging?
has done the right thing. If they really want to change the position on material information, it's far simpler rather than going around prosecuting people to get the portals to agree with you, because they are for most people the starting point. But I don't think there's anything terribly surprising in the letting stuff. The idea that the rent level and the amount you're expecting and what you're expected to be paid on, and the deposit level and the council tax, I don't think anyone would really suggest that they're not relevant material information. Of course, tenants want to know what it's going to cost them. I mean, I think the estate agency one is a bit more subtle and a little bit more complex, but it's slightly outside our remit. But I know people are going to ask, so let's just talk about it.
Should we jump into the sales side, because it's more extensive there? Tenure is covered, so whether it's freehold or leasehold, and you may query whether that is material information based on whether the extent to which the general public may understand the difference between the two. Quite extensive, and I guess more prescriptive information about common hold, which ties to the current government drive, or the reinvigorated drive to push out common hold, and the price expressed as a single amount. And I'm preempting questions. So what's your take on the provision of price as a single amount for a sale?
I mean, let's just go through all of it. I mean, tenure type, sure. But I think once you start to get into details of it, you're in danger of shading over into the conveyancing process on a sale. And there is case law from the old Property Misdescriptions Act that covering, for example, restrictive covenants and things like that, where courts have held that that was actually a matter for dealing with in the conveyancing process. So I think the government has hinted several times that it wants to essentially force people to give out much more information at a much earlier stage. But inevitably, the more you do that, the more you've got to question whether we shouldn't, in fact, move to a US model where estate agents are, in fact, realtors and, in fact, conveyance as well as sell. And that's quite a radical departure from the way that we deal with property in the UK. Well, it has to be said, it's one I've advocated as it happens, and which we could actually do now. And I've pressed people to do it, but no one was terribly keen. But it's clear that that's what NTS ELAT is thinking about. In terms of sale price, I'm not convinced. I mean, I don't think there's anything wrong with listing a price as offers over, or giving a band or nearest offer. And I know that NTS ELAT has, in a press release, has said you have to do it. But when you actually look at the detailed document behind it, they've got a little footnote that says it's subject to legal advice, which basically means that they don't know. And they're thinking about it. And even if they get legal advice that says you have to do it, it's for the courts to decide. And I would be very surprised if a court suggested that advertising a property as offers over, if you were prepared to accept the price that you put out there, but were happy for the market to dictate it, would be wrong. And the reality is, at the current time, this is pretty much where all pricing is. If you advertise property for sale in Surrey at the moment, the level of demand is so high that the chances are it's almost certainly, unless you've been really enthusiastic with your price, it's very likely to go for more than the price that is actually on the table in the initial ad. So I don't understand where NTS ELAT is going to go with this, but I don't accept that you have to write a single price, which is the only price. This is property, it's not apples.
Thank you. And recognizing we've got quite a lot to jump through, so we're going to move on to...
I was going to say, even apples are negotiable, because I saw The Apprentice.
Okay. Signing prescribed information and possession notices. So if you've tuned in previously, we've talked pretty extensively about the Northwood Solihull case. David, you were intimately involved in it, and there's been a huge amount of press, but would you be happy to give a sort of brief overview of where we are now, and perhaps why there might be a collective sigh of relief across the sector?
Oh, I was about to say, as of yesterday, there might not be, but the tenant has indicated an intention to take it to the Supreme Court. Now, if I'm honest, I would be quite surprised if the Supreme Court was prepared to hear this case. I don't think it's actually sufficiently important But I should also point out Caroline Ransfield and gas safety is sitting waiting for permission before the Supreme Court as well, and has been for like a year.
Yep.
So, if they took that case, it would perhaps indicate they might be prepared to take this case, but we just don't know. It's not something I would expect the current composition of the Supreme Court to be interested in. So there's a semi-side relief, but I wouldn't say it was a permanent one. But yeah, the summary position is if you sign a Section 8 notice or deposit prescribed information, or by extension a Section 21, then provided it is signed by somebody in your office who has a job title that makes it reasonable for them to sign it, then that will be fine. It does not need to be signed by a director. It does not need to be signed by a director before witnesses. And ideally, you should make clear, of course, that you're signing it as the landlord's agent.
Yeah.
But even if you get that slightly wrong, the Court of Appeal wasn't terribly fussed. And the general tenor here, and I think it was really notable, the decision was actually turned around in 8 days, which is, it's the fastest I've heard of, apart from really, really urgent, special cases like, where with children in care who are dying and things like that, really complex stuff. So the turnaround was very fast, which clearly means that the Court of Appeal was of a mind before they even started hearing it.
Yep.
But I think it's notable that it continues a line of cases that have been going through in the last 2 years, really, which make clear that Section 8 and 21 notices are not a trick or a game that are intended to trip up landlords. It is a reasonable notice for the occupation of reasonable people without involving lawyers looking at every single notice, though of course I would love it if you did. But the reality is that these are notices that are served by practical people on a day-to-day basis.
Yep.
And so, there's got to be some degree of balance, and the Court of Appeal backstopped its position by saying even if we were wrong, they were wrong about the notice, the signature stuff, everything else was clear. And so a reasonable tenant would know what was required. It was pretty obvious that the tenant had got the information about the deposit. It's pretty obvious that they were being asked to leave. What else do you need? I don't think that the tenants' lawyers helped themselves in the Court of Appeal when they at one point suggested that every notice in relation to property signed by a company ever across every type of tenancy was potentially defective, which was not an outcome that the Court of Appeal was particularly impressed by.
So pending appeal, which may or may not be granted, we're in a sensible position and the right position, really. It gives certainty, it removes trickery and chicanery. And for everyone on today's webinar, we're going to send out a guide on digital signatures, a guide about deposit handling, which covers prescribed information. So there'll be various information, but I guess we're now in a much clearer, and I would argue a much better position. Are there any other words of advice other than don't worry so much, as you may have been worrying over past months?
Well, I mean, the situation is now restored to where it was before all of this started.
Yep.
And people can crack on and get signing. I mean, I can't say to you that there won't be further attempts to take this to the Court of Appeal. I'm quite sure that, or things like it to the Court of Appeal, and people will continue to try and produce these technical defences. But the reality is the Court of Appeal has generally demonstrated it's not terribly interested in them.
Thank you. And we'll move on to new tenant reference checks. This, I think, is quite interesting because of an increasing use of open banking. But would you be happy to talk through the Hunter's case, its background, and what it actually means for agents?
Yeah, I mean, I've read this differently from a lot of people, so I think I'm quite interested in it. But obviously, most people are no doubt aware that the Tenant Fees Act has commentary about holding deposits in it and when they can and cannot be returned. And tenants are entitled to take their cases to the first tier tribunal. Mm-hmm. There have been about 24 cases before the first tier tribunal on tenant fees, the vast majority of which are about holding deposits and whether or not they should be returned. Something like 22 of 24 are about holding deposits based on their returnability. And the other two cases were stupid anyway. I mean, both of them were things that were patently and obviously illegal under the Tenant Fees Act, and were really just holdovers from early phases of the Act where people hadn't got their heads around it. There's obviously stuff on more recent stuff, obviously with on termination fees, but that's a separate topic. But there was quite an interesting case recently, which I thought was interesting, where a tenant had submitted referencing through Hunters and their approved referencing company, which I think is Paragon off the top of my head, but I can't remember. A referencing agency, doesn't matter particularly. The referencing agency had basically turned around and said, well, based on the documents we've got, we can't approve him, but if he was to allow us open banking access, then we're confident that we would be able to approve him. And the tenant turned around and said, I'm not giving you access to my open banking, outrageous invasion of privacy, the kind of stuff that's actually been in the press. People have seen, I'm no doubt seen articles in various newspapers saying that tenants complaining that open banking is complete invasion of their privacy, although I'm not convinced that it's any more invasive than asking for a bank statement, frankly, but fair enough. And the Hunter said, well, if you won't give us open banking access, then you failed the reference and we're keeping your money because you didn't tell us everything. And then this went up to the FTT. And the argument ultimately that came before the FTT was whether the tenant had done enough, because the requirement of the legislation is the tenant has to act in a reasonable and sufficient manner and do enough to allow the thing to progress. And the FTT said that asking for open banking information was reasonable, especially as it hadn't come from Hunters, it had come from a reasonable and reputable referencing agency. And by refusing that request, the tenant hadn't done enough to progress the tenancy. So I thought the thing that I thought was interesting out of all of this is obviously there's a bit of an increased use of open banking. There has been suggestions that it's unreasonable. It appears that the FTT is of the view that there's nothing particularly wrong with open banking, although I would say that it's probably safer to ask for something other, some arguably less intrusive mechanism first. But that's a matter of viewpoint, I suspect. I mean, the real takeaway from this, I think, is that open banking is not quite as bad from the FTT's point of view as other people.
And I'm going to slightly tortuously link this to a very different case about deposits alternatives or no deposit schemes. So there was a recent case about that. Would you be happy to sort of give a summary as to?
Yeah, I think that case has now died the death.
Yep.
But it had been suggested by a judge at first instance that it was possible that a tenant hadn't been given proper alternative. So it's important to bear in mind, and I don't think all agents have fully got their heads around this, that zero deposit schemes can't be offered unless as an alternative to a deposit, because zero deposit schemes in and of themselves are unlawful under the Tenant Fees Act, because you're asking someone to pay money, and they're not in the list of approved things. They could be, and the government could change it, but they haven't. But provided you offer it as a genuine alternative to a deposit, then it's okay. But that's where it gets a bit odd. I mean, the first point is not all agents are very good about making clear that it's an alternative. And I think they need to make sure they keep records, because it's an obvious challenge in every zero deposit case to say, I wasn't really offered an alternative. The only thing they gave me was a zero deposit option and browbeat me into doing it. So make sure you've got evidence of that. And then the second point is, how reasonable does the alternative need to be? There's an aspect in which, especially as zero deposit schemes get cheaper and cheaper, the alternative between paying 6 weeks rent or 5 or 6 weeks rent, depending on the amount of the tenancy value, as against a zero deposit, the zero deposit becomes so much cheaper that it's not really a reasonable alternative anymore. You would always take the zero deposit option. So I think the difficulty with this whole alternative requirement is the legislation simply says there has to be an alternative. There's nothing in there about it having to be reasonable. And so I said when this legislation was first introduced, does that mean I could charge for referencing, provided I give the tenant an alternative to not paying me for referencing, however unviable and ridiculous it might be? So, you could say, well, you can go and get the referencing yourself, but we'll only accept this really long list of stuff, or you can pay us money and use our referencing service. And I'm not sure where the law is on this.
I wouldn't want to argue that in court, because I think,
well, it would be a tough call. I don't think you'd win it first time out before the FTT, but the reality is my lights have just turned off for no good reason in this office. The reality is that the law is quite clear about what it says, and it would be up to a higher court to choose to read it in a non-plain English fashion. The starting point of the statutory interpretation is to read it in a plain English fashion. The tenant's been offered an alternative, provided it's a viable one, and there are reasons for offering it, then I'm not sure whether that alternative has to be a good alternative. That's the thing that I'm not clear on. And also, there's a world of difference between a reasonable alternative and an alternative I might in fact be prepared to accept.
We'll move on to the next topic, which has been a mainstay of this webinar series. Weirdly, two things to highlight. So we're talking about rights to rent checks. So it's been a mainstay because the rules have changed, the timeframes have changed.
Too many times.
It's changing again. This is the important thing. So if you take away anything about this, please take away that from the 6th of April of this year, they're changing again. What is changing, David? What do agents need to know?
The first point I would make is that we're still not 100% sure, because the full code of practice is yet to be published. And I suspect if the Home Office is true to form, it'll probably be published around about the 5th of April.
Yep.
They may surprise me and it'll appear next week. Who knows? At some level, I don't think anything's changing. The information I have, and obviously it's not necessarily much more than anybody else's, is that you will still be able to carry out traditional right to rent check on paper. What the government is doing is it's forcing you to use the online check for people who are within that regime. So there is an online checking regime for people who have got settled status. You must now use that. There is an online checking regime for people with certain visa criteria and right to remain biometric permits. You must now use that. But the difficulty is that people have turned around to the Home Office and said, well, why can't we have online checking for everything? And they've recognized that's a good idea. But of course, you can't have online checking for everything, because that would be tantamount to having ID cards for all UK nationals. And the Conservative government is never, ever, under any circumstances, going to introduce ID cards for all UK nationals, because Boris would be out the door in 0 seconds flat. There's just no way that the right wing of his party would ever accept that. So they're not going to be able to do that. So what they've basically done is they've created a scheme called IDVT, which is basically a trust arrangement that individual partners can sign up to with the Home Office to have an identity checking service online. And it's actually for a range of things. It doesn't have to be used for right to rent. It will probably end up being used for a range of different stuff. I would expect over time it will migrate into banking and things like that. In other countries, that's exactly what happens. But the idea is that these companies will set it up. People will then sign up to an IDVT partner themselves, verify their ID with the IDVT partner, and then that can be passed through for right to rent checks. And this is aimed specifically at UK and Irish nationals.
Yep.
So the objective here is to basically put UK and Irish nationals on the same footing as people who are using the Home Office's scheme. So in principle, if a UK or Irish national has gone through the IDVT system, you will then be able to do their ID checks with them online. And equally, if someone comes to you saying, I've got settled status, you can do their ID checks, but through a different online system. Obviously, they're not the same system, because that'd be far too easy. Two separate systems. Again, the thing that there are several problems with this. First, of course, the IDVT scheme works on APIs, so it will be more tightly integrated into agents' computers. So it will be a lot easier in the end to check people who have got a UK and Irish passport, which is likely to lead to further discrimination that already exists in the right to rent scheme. It's known to be discriminatory. The Home Office has admitted it's discriminatory. They've also said it's not their problem because it's landlords doing the discriminating, and the courts agreed. So it's likely to get more discriminatory in practice, even if people aren't doing it intentionally. The second problem, I think, will be that some people will not want to sign up to IDVT systems, and some tenants will push back and say, I'm not required to sign up to this. Why you want me to put my stuff into yet another computer? No, 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 no. How will you deal with that? You're not really entitled to refuse them on that basis. And the third problem will be, I suspect you'll find that most IDVT systems will be quite passport focused. And if I don't hold a passport, like 12 million people in the United Kingdom don't, how do you get signed up through an IDVT system?
Sorry, 12 million people in the UK do not hold a passport.
No.
That's interesting.
I mean, the number varies up and down. It's between about 9 and 12, depending on who you ask. But by definition, we don't really know because they don't hold a passport. And we've got no ID card system. So the difficulty is that quite a lot of people in the UK don't hold a passport. And obviously, unsurprisingly, they tend to be poorer people or older people, many of whom are in the private rented sector. So there has always been this problem that and I actually crossed swords with a member of parliament when this was being introduced, who cheerfully told me I knew nothing about the sector because it was no problem. He'd gone and rented a flat in Dolphin Square, and they asked his passport. He'd shown the passport. There was no issue. And I firmly but politely pointed out to him his experience of renting an upmarket London establishment paid for by the state, ultimately paid for by my taxes, may not be exactly the same as the rental experience of other people in the sector.
So on that, so just as a reminder to everyone in the audience, we'd love to have your questions, comments, insights, and they're coming in thick and fast, and we'll come to them at the end, so we've got allotted time. But if you have any views on whether this is going to help or hinder your processes, whether it's actually going to make any material difference, please put it in. I'd love to hear from you, and we'll go through those comments. I'd like to move on to the second highlighted topic here, which is levelling up decent homes. So I'm going to start with my view, which is a patchwork quilt is not a helpful place to provide certainty and allow people to drive their decisions. And with that very biased overview, David, what do you think about, well, let's start more broadly. What do you think about the government's pledges to level up? Perhaps even delving slightly into the rebranding of DLUC, so Department for Levelling Up Homes and Communities. I've got that wrong.
DLUC, I've heard it called many things recently. The harshest one I heard was lame duck, but let's not DLUC. What's in a name? Departments are renamed all the time. At some level, it's irrelevant, but clearly, levelling up is of more interest. And I've been of the view since this happened that it represents a decreased level of interest in the PRS. Michael Gove's work primarily recently has been on fire safety and leaseholders and cladding. Previously, it was mostly left to junior ministers to talk about it. Michael Gove's now very directly into that discussion. Obviously, Eddie Hughes has remained in place throughout, even through more recent reshuffles that saw other housing ministers replaced, and he is leading on the PRS white paper. But it is now a white paper. It is no longer a renters reform bill. It is a renters reform white paper. I noticed that the levelling up white paper mentioned that there was going to be a renters reform white paper. So it's the first white paper I've seen that mentioned another white paper. It's not normal for white papers to promise a white paper. Normally white papers promise a bill or a piece of legislation, not another study. And then where are we actually going with the white paper? It's notable that there continues to be talk about getting rid of Section 21, but will they, won't they? I'm still not 100% sure that they in fact will. And it's certainly clear that there's more of an interest in standards, and there's a lot more talk now about national landlord registration schemes, and a lot more talk about landlord ombudsman.
We're going to come to landlord registration in a moment, but specifically around the decent home standard.
So the levelling up white paper said that they would impose the decent home standard and review it and impose it to the PRS. The decent home standard exists in social housing. It's quite a low level standard. If your property meets the decent home standard, it does not mean it's a nice place to live. It broadly means that it's wind and watertight and there isn't water streaming down the walls and stuff basically works. So it's generally quite a lowbrow standard compared to other standards existent in the PRS. The The other difficulty with it is, of course, it's yet another standard. So the PRS already is subject to Section 11 of the Landlord and Tenant Act, 1985, standard repairing obligations. It is already subject to the Environmental Protection Act. It has been made subject to the Homes Fitness for Human Habitation Act, which of course feeds back into the Landlord and Tenant Act 1985. Yep. It is subject to the Housing Health and Safety Rating System. I was going to say HHSRS, but someone quite reasonably said in the comments, stop using acronyms, so I won't, and I might torture them later. So the Housing Health and Safety Rating System it's subject to as well. So where do you fit the Decent Home Standard into that? Does that mean it's another standard enforced by local authorities alongside the HHSRS, in which case, what's the point? Because the HHSRS already does it.
Yep.
Or are you getting rid of the HHSRS, which seems a bit bonkers because you're already currently reviewing the HHSRS and it's going to be updated anyway? Do you place the Decent Home Standard inside the HHSRS, so it's a sort of minimum floor level within the HHSRS, or is it something else?
So, upshot for people on today's call is, I guess my narrative is, there are multiple things that currently apply to properties. That's not something new.
Raj just doesn't seem. Sorry, Raj, you just phrased there. Your narrative was
that there are multiple applicable standards for properties, and they overlap, and there doesn't seem to be a move to consolidate them. And without consolidation, it is very hard, or harder than it ought to be, for people trying to do the right thing to do the right thing, because it's complex. Part of the job of part of good law is clear, understandable, prospective, stable laws, so people can modify their behaviors and try and have a good chance of being able to comply. And this just isn't that.
Legal theory as well, before midday as well. Yeah, I mean, the whole thesis of legal regulation and regulation in general is to have a clear regulatory standard that's consistently enforced.
Yep.
As everyone is fully aware, one of the problems with the PRS is that we do not have a clear regulatory standard. We have several of them, which obviously is fabulous for lawyers like myself, but not terribly useful for individuals. And it is inconsistently enforced. And adding another standard, which is probably going to be asked to be enforced by local authorities who are not currently the most consistent enforcers of standards.
Yep.
Which doesn't add anything beyond the existing standards that local authorities can already enforce. Doesn't seem to take us anywhere. And I do wonder if this is just there to talk about standards and to have an announcement. And bear in mind, government likes announcements.
Mm-hmm.
And I mean, to be fair, the Decent Home Standard is used in the PRS, but only by the English Housing Survey. So they use it as a mechanism for assessing what the state of stock is.
Yep.
So there is a logic to bring it into play, but it's not going to add anything. If your house is in repair and meets the HHSRS, there's no risk of you not meeting the Decent Home Standard. But if you're just crawling over the Decent Home Standard, it is more likely than not the local authorities going to be coming through your door serving you notices under the HHSRS. If your property, I mean, but by the same time, if your property just meets Section 11 standards, it's not that great a place to live. That's quite a low-level standard, and the vast majority of properties in the PRS are higher than that.
Yep.
And the problem has always been, really, not that we don't have standards, but that enforcement is very, very patchy, and bad landlords get away with it again and again and again and again and again. And I don't see that the Decent Home Standard, without actually giving local authorities real funding and real training and real support, changes anything.
But real funding, real training, and real support is significantly more expensive than making an announcement. And so
that's all. Don't be so cynical. It'll all be fine.
And so I'd love to move on to the state of landlord registration. David, as always, you have interesting, and I'm going to say in this case, quite forceful views on landlord registration. So where are we with landlord registration, and what are the views that you would be happy to share with today's audience about what's being mooted?
Well, as some people know, I've written a lot about it. I have actually stuck on my LinkedIn somewhere a paper I wrote for a law journal reviewing all the different landlord registration schemes in the UK. I mean, the trouble is that the government's very unclear what it means by landlord registration. What they've said so far is a bit nebulous, and landlord registration is very different in different parts of the country. So Northern Ireland, for example, has incredibly light touch landlord registration. It costs about £20. It's a list of all the landlords. Every landlord has a number. You have to tell the tenant what your number is.
Yep.
And it's not much more than that. Now, that would fit some of the declared aims of the English government, which is basically to know how many landlords there are and also to be able to communicate with them easily. That would be a landlord registration scheme, and it would be very light touch. But equally, if you go to Wales, landlords must be registered and licensed if they want to manage their own properties or use someone who is. They must go on training courses. There is a code of practice. It costs a lot more money. It's much more aggressively enforced. That is a very heavy touch landlord registration scheme. If you want to introduce that in England, that's going to be a lot more controversial. It also starts to call into question the purpose of selective licensing. It is notable that while selective licensing still exists in Wales, there is no local authority with a selective licensing scheme. And before Rent Smart Wales was introduced, every local authority had a selective licensing scheme in Wales, pretty much. Now, none of them do. And given that there's a big growth of selective licensing in England, you've got to question whether a localized selective licensing scheme can legitimately coexist alongside any form of landlord registration scheme, because they frequently do similar things.
Yep.
Now, obviously, selective licensing often includes management standards, but in practice, it's mostly there for local authorities to have information about landlords in their area. And if they're getting that anyway, then they probably don't need selective licensing. And the other point I would kind of make is that actually landlords are required to sign up with the data protection registrar, with the ICO for data protection purposes. So what's wrong with that list? Landlords, it's long been clear that information can be gained from council tax returns about landlords, and indeed all local authorities were written to by the Secretary of State for MHCLG at the time to tell them this, which was nearly 5 years ago now. It was about 5 secretaries of state ago, obviously.
Yeah.
You know, there's been numerous there's numerous mechanisms by which local authorities and people can find out who's a landlord. You don't need a landlord registration scheme, and of course, it remains the perennial problem of the private renter sector is how will you enforce it, and how will you find the landlords who haven't signed up and make them sign up. And if they don't sign up, then you don't actually have an accurate picture, and the information is useless. And all you've really done is put an imposition on landlords who are already signed up. And then I suppose you need to start thinking about how you interact it with agent registration. Is it worth making landlords who've got a letting agent doing all their management sign up for another registration scheme, or should they just get a buy? How do you manage that process? And then the side thing that I haven't even gotten to yet is landlord ombudsman schemes. So one of the side effects of this, people want to have an ombudsman scheme to make complaints about landlords, but what's it going to do that's not being done somewhere else? And how much should it do? Should it handle disrepair complaints, which actually should be in the courts? Should it handle Tenant Fees Act complaints, which should be before the FTT? Should it handle all of those things, in which case let's make all those things obsolete? And then how do you manage the interaction with those complaints with possession proceedings, which almost always inevitably link together? Most tenants complain about other stuff when you try and take possession of the property.
Another patchwork.
It does become a bit patchwork.
It's quite interesting.
And in some senses, it's just admitting that the courts aren't able to handle the job. I mean, they're not doing the job properly, or they're not available enough to people. Would we not be better off to throw some more money at actually making the first-tier tribunal system and the court system work effectively for tenants as well as landlords, so that you don't have to have all these different regimes? You have one. You do what Scotland's done, for example. You shift everything into the first-tier tribunal, and it's all handled in one place.
Yep.
And you throw money at it to make it work effectively.
Running slightly ahead of time, but also thank you very much to the audience for the immense number of questions and comments. Starting at the very top, material information. For anyone who hasn't seen it, there is very little. Well, when I looked earlier, there was very little actual information about what material information comprised. It was basically 12 bullet points, but a question that's come in, which is what when displaying the deposit amount on a lettings listing, what's required? It could be two possible amounts of deposit for each listing, depending on whether it's an AST or common law agreement. I've interpreted the question. So what happens?
Yeah, that is a part of the thing that the NTSLAT doesn't really understand. I mean, the reality is the NTSLAT doesn't understand the Tenant Fees Act. In common with government, they still seem to think that the only type of tenancy available in the whole world is the AST, and they don't understand that there might be other possibilities. And I mean, this is part of the problem. I mean, you might have a higher rent if there's a pet, for example, pet rent. Yeah. The NTSLAT hates it, but it's legal.
Yep.
You might have a different deposit and a different fee structure if it's being let to a company. NTSLAT will hate that, but it's legal. And this is why their list is nothing more than their view.
A comment from Eric Walker: the single price thing is nonsense. Think auctions. I don't think he's asking for a response. So it's just an expression of exasperation, perhaps.
And he's quite right. I mean, it is this whole idea that you could have a fixed fee for selling a property is just not. I mean, in certain markets you might, but not in the current one.
EPCs, is the requirement to have an EPC C rating in 2025 law, or is it still pending?
It's very much pending, and I wouldn't even guarantee to you that it's 2025. The government expressed a range of dates between 2025 and 2028 in their original consultation, and has also at least canvassed the possibility that it might actually be phased. And the difficulty with this one is one, what do you mean by a C rating? Because the consultation actually discusses two possible ratings: an EPC, an Energy Performance Certificate, which is basically a calculation of how much it costs to heat and light your property in a year. And just as an aside here, I'd point out, if your property is gas, I suggest you get your EPC done now, because it's going to go up soon, and you will actually go down a band because gas prices run on a 3-month rolling average for EPC purposes. So you're going to find that most gas-powered properties are going to get worse quite soon as price caps as new prices kick in. But the other thing the government's canvassed is what's called an ECC, which is an Energy Carbon Certificate, which actually measures how much carbon your property produces. So you can game an EPC in theory by having a really rubbish property where the heating's on full power all the time, but covering it in solar panels. And that would give you quite a decent rating. But obviously you'd be producing a hell of a lot of carbon if your heating's powered by gas, for example, or oil. So the government's yet to decide whether future energy performance ratings will be the EPC, the ECC, or some combination of the two, and what the weighting will be. So you can't even say for sure what a C actually means. And then the other difficulty with all of this is when we did this last time, some people went, and the other point is that the government also hasn't decided what the threshold figure is going to be. They've named £10,000. Last time out, they named £5,000, and it ended up at 3,500, which was a number that nobody was proposing. It was just sort of in the middle of a number of different pitches. So I wouldn't bet it's going to be 10 grand. And the other problem last time out was that people who jumped early and spent their money then discovered, when the government finally brought in the regulations to bring it into force, that the money they'd spent was discounted because they'd spent it too early.
Yep.
And so they had to effectively spend 3.5 grand again. So I think while I would normally say, of course, the right thing to do is jump on it and get the thing early, if you can't ever get your property up to a C rating, then you probably technically shouldn't jump early, because if you spend your money now, you may not be able to rely on that spending to say, sorry, I've spent 10 grand, I've still got a D. You should let me let it out anyway, because the exemption might require you to spend another 10 grand on top of the 10 you've already spent to get that. So the government, I mean, if the government wants to sort this out, they need to, again, this is back to the point earlier, they need to be consistent. They need to tell us what the law is going to be, and they need to say it now, because these are things that you know, the government thinks, oh, well, it's still 3 years or 5 years away, but these are substantial pieces of work, and people will try and plan them in. They're not things that you can do easily with tenants in place.
And they're going to start factoring into mortgage decisions and remortgage. the knock-on consequences or the
Well, and you're already seeing knock-on consequences. I saw something this week that suggests that properties that don't have C rating are being unfavoured by landlords. Landlords don't want them, which means, of course, the market's already distorting.
Yep.
As a result of publicity around this thing, even though it had actually been around for over a year, the publicity has got bigger after COP26, and it's slowly distorting the market, and that will only get worse. And of course, the people who will lose out the most will be first-time buyers who think they're getting cheap properties, or think but properties that mortgage companies will be reluctant to lend on. And mortgage companies are being pressured by the government not to lend on properties that are below a C. So people are going to end up buying a property now, getting a mortgage now, and then they'll come to remortgage it in a few years' time and discover that the only people who will remortgage to them are subprime lenders.
Yep. We're going to move on to the next section, which is signing prescribed information and possession notices. So a range of different questions. And just as a reminder, today is not the provision of legal advice and must not be construed as such. And so with that, you alluded to the person who signs the document having an appropriate job title, which would indicate their ability to sign. Are you able to give a steer on the sorts of job titles you would expect, and perhaps even more usefully, the sorts of job titles you might not expect?
I mean, the reality is that all the Court of Appeal said that the person who had signed it in Northwood case was described as a property manager. So if you are authorized by the business to do this, and it doesn't have to be a formal authorization as such, so that would be either, it might be in your job description, and there's obviously a case here for updating people's job descriptions, which as a hint, you should be doing anyway regularly as it happens as a matter of employment law. And also, your job title indicates that you'd be likely to be a person who likes to sign notices, then that would be fine. So a property manager is likely to be fine. Someone who's in their job description is likely to be fine. If you're expecting your office cleaner to sign these notices, then that is not likely to be fine. There is no deliberately, in a sense, no hard and fast rule about this. If you are appropriately authorized by the business to sign these things, and that doesn't have to be a board resolution, but it could be, then that will be acceptable. It does not have to be in your terms of business or anything like that.
Okay, that was the next.
I saw the question.
Okay, good. Sorry, I'm going to have to reframe the next one because it's relatively complex. But as a limited company, do we need to sign the deposit prescribed information as a director or witness, or has this been changed?
That is precisely the point of the Northwood Solihull decision, the Court of Appeal. No, you do not. A director, of course, can sign it, but they can sign it merely as an important person in the company who has appropriate authority. They do not need to sign it in their capacity as a director before a witness.
I think my understanding of the question before was slightly incorrect. I think I've now understood it. So if the prescribed information is included within the tenancy agreement, does the prescribed information itself need to be signed, or would it be deemed signed if the tenancy agreement is signed?
Good question. Don't know. I would advise you. I mean, it depends how you include it and how you word the tenancy. To be honest with you, I could see ways of including it in such a way as it could you could do it with one signature. But to be honest with you, I think you're just trying to make your life difficult and drive you into a position where you need to phone me up and give me money.
Yes.
To be honest with you, I mean, surely it's not going to be so difficult to have two signatures.
Holding deposits.
Mm-hmm.
I think we've got time for in what circumstance, I think the questions are pretty specific, but just a more general one, which is, in what circumstance could a holding deposit be retained, i.e. not repaid? So tenant not proceeding, tenant not providing material information. What are the circumstances in which holding deposits can be retained?
Well, mostly set out in the Tenant Fees Act, but ideally your tenant holding deposit agreement should be clear. But normally, tenant not taking reasonable steps to proceed, so not providing you with information when asked on reasonable timelines, going beyond the 15-day threshold without agreeing an extension and it being the tenant's responsibility, and not being honest with you. I mean, you tend to find that they all fall into two criteria. Either the tenant has not filled in the pre-referencing form accurately, and the reference comes back and says, yes, they've got CCJ when they said they didn't. It's an obvious example, comes up quite a lot. Or the tenant failing a right to rent check, or a tenant having been asked whether or not they had a right to rent, or a tenant simply not providing documents promptly or at all, or declining to. And then obviously tenants pulling out.
Thank you very much. How to rent guide, slight jump there. So are you aware of any obvious changes to the current how to rent guide in comparison to the last version?
No, no one's very sure what's changed. It is a tiny sentence hidden somewhere in it, which actually is of little interest to anybody. I mean, I suppose what you should really be asking is, when do I think it's going to change again? My understanding is that DLUHC has accepted that they do need to give more notice of how to rent guide changes. And the last one they did flag up in advance. Mm-hmm. I would hope that they would continue to do that. But then at the same time, Section 8 and 21 notices have been changing still on very, very short notice. So we'll have to see whether that actually happens. I mean, I don't expect it to change for a bit now. The most likely next change might be April if we sort out the changes to carbon monoxide alarms.
There's a pretty detailed question that's come in about a tenant leaving early and the ability to claim reletting fees for the surrender. My guess from reading the question is that person would be best to contact you directly for advice on their specific circumstances. But do you have a general high level you're able to provide on when reletting fees would be appropriate?
I mean, the first point to make here is that people keep getting this mixed up, and I point out that this is not just agents. There are ombudsman schemes and others who get themselves in a right confusion here. Agents don't charge reletting fees to tenants. How could you possibly? You don't have a contract.
Yep.
Agents charge landlords the costs associated with finding a new tenant, because in practice what happens, of course, is an agent says, right, we're charging you X for having found your tenant for 12 months, and we will agree to split that fee across 12 months, and we will take it in dribs and drabs rather than taking it all up front from the rent. The tenant then leaves. The agent says, well, to the landlord, well, you still owe me for finding the tenant, and I agreed to share the fee out, but you've accepted an early surrender, so I want the rest of my money now. The landlord says, fine, I'll pay it to you, but I want it back from the tenant. Mm-hmm. So what actually is happening here is that tenants are saying, I want to surrender early, and the landlord is saying, yes, that's fine, but on condition you pay my costs. And that is perfectly allowed under the Tenant Fees Act. Now, a number of organisations have inserted themselves incorrectly, in my view, and unhelpfully into this debate by trying to analyse whether the fee being charged to the landlord was reasonable or not. I don't think they can do that. It's none of their business. That's the landlord's complaint, not the tenant's complaint. If there's a terms of business between a landlord and an agent that says this is what it's going to cost you if you allow the tenant to leave early, then the landlord is entitled to pass that cost on to the tenant. At the end of the day, landlords are not obliged to allow tenants to surrender. They can simply say no. And so tenants are asking, and the Tenant Fees Act wasn't intended to change the basic position. I mean, there's a problem here. The Tenant Fees Act is not well worded in this area. The guidance is bizarrely worded and plainly wrong, frankly, in this area. But there's also a difficulty that people misunderstand it. Bear in mind, the Tenant Fees Act didn't just deal with letting agents, it also deals with relocation agents who act for tenants, and was intended to some extent to limit aspects of their fee structure as well. And it seems to me that a certain amount of the wording and guidance about agent fees on termination is actually directed more at relocation agents than it is directed at letting agents.
Thank you very much. Just a very general question, because over the past large number of months, we've been talking about the courts being gummed up. What are you and your colleagues seeing in practice in terms of being able to get hearings and delays. Are things unlocking or not?
It's all over the place.
Okay.
I mean, the thing that, well, there's several things going on. I mean, numbers on the quarterly returns in terms of applied cases were still low. They're starting to come back up to pre-COVID levels, but social landlords still aren't really in the mix. Some of them have been restraining still, and obviously Wales is in the mix because you can't serve notices as easily in Wales until March at least. So Wales isn't really in the figures either. So they're kind of off back a little bit. The other thing that's difficult is bailiffs still appear to be a problem. There's real difficulty once you've got your possession order and actually obtaining a bailiff's warrant in any reasonable pace. In the courts themselves, it's hugely variable. Some courts are processing paperwork quite quickly. Some are very slow. More commonly, they're really quick and slow simultaneously. So I've had cases where the paperwork's turned around really fast, and then others where it's basically been lost.
Okay.
And then listings of hearings, I've had some where I get a listing months and months and months away, and I've had other ones where I've got a letter that's taken ages to get to me, but is listing a hearing less than 2 weeks away. I've had orders that have taken 2 months to be typed up. I've had orders back in a week. So the real position is one of appalling inconsistency. And it remains my advice, and has always been my advice, but more so during COVID, is if you can come to a deal for the tenant to leave, where you write down the rent arrears you probably weren't going to collect anyway, you should take the deal. And it remains the case that most of my cases do not go through full contested hearings and possession orders. Most of them end up in a deal at the moment, more so than before.
Brilliant. And with that, thank you to everyone who tuned in today. If you could please take 10 seconds to provide feedback. We'd love to know which topics you'd love for us to cover over coming webinars. And thank you very much to David. David, thank you for your preparation and your wonderful insights. For anyone who is interested in keeping up to date with ebooks, white papers, and invites to future webinars, please follow Fixflo on all good social media channels. And if you've got any feedback you'd like to provide us directly, please email research@fixflo.com. And with that, thank you all very much and have a wonderful day.